Just in, the SAC Chair Gary Gensler discusses the Ripple XRP judgment for the first time since the court decision last week. Gary appears to be very disappointed. The new district judge Torres has referred the Ripple case to Magistrate Judge Netburn for general pretrial, which includes scheduling, descheduling discovery, non-dispositive pretrial motions, and settlement. As I recall, Sarah Netburn was the judge who said the SEC lacked a faithful allegiance to the law with regard to this case. Recently, Lunar Crush revealed that XRP's social activity increased significantly last week after the asset flip death and social dominance. At the time, XRP was only second to BTC in terms of social engagements, with 31,000, while ETH saw engagements of 20,000, according to Lunar Crush. The previous 10 minutes have seen a significant increase in XRP social activity, which has continued to demonstrate strength, with XRP outpacing ETH and USDT and trailing just BTC in terms of social engagements. We have seen many critics of Bitcoin Maxis in the past, but they are now effectively silenced thanks to the verdict, which was beneficial not just for XRP, but for the entire cryptocurrency community. Recently, XRP trade volume has been through the roof, which has led to an enormous increase in overall trading on exchanges like Binance. On July 13th, XRP 24-hour volume was at a whopping $10 billion, but it has since dropped to an impressive $3 billion. At the moment, Binance is absolutely crushing it in the volume game, handling a huge $688 million in trades, accounting for about 21% of the total volume. The list is sitting in 9th place with a volume of $50 million anyway. It's clear that XRP is making some major waves in the market, and people are jumping in on the action. It's going to be interesting to see how things unfold from here when you think about the intergenerational wealth. This next generation, basically, the millennial, although it's pretty much anyone born in the mid-90s and later, are going to inherit this opportunity to really think about investments in a totally different way. So when you think about those generations so technically, the millennial or anyone born between 1980 and 1996, I refer to them as the Robin Hood investors, but in reality, these are young people who grew up with the internet. And anyone who has grown up with the internet sees the world as being very flat. It's not what they were taught at home or in school, but rather what they have observed and learned, the good and the bad. The internet's ugly people are very tech-savvy and self-assured, but they lack the experience that many wealth managers, financial analysts, managers, and others may need to truly understand how to think about their investments. The world is something that can be completed in one go, and they place a high value on technology. They are also extremely self-assured, progressive, and astute, but once more, they lack empathy. Instead of buying them dinner and taking them out to play golf, it's more important to think about how to use technology and information in a completely new way. If you aren't already on their phone's app, which is how they access information, you already know you're behind and will soon catch up. A well-known proponent of cryptocurrencies shared some information during a recent Twitter conversation with former SEC Director Mark Fagel and other XRP enthusiasts. During the conversation, one XRP enthusiast claimed that Deaton had stated that none of the parties involved could appeal Judge Torres' ruling until after the trial issue had been resolved. However, Fagel disagreed. Deaton subsequently stated that he never intended to imply that an appeal wouldn't be possible prior to a jury judgment, and he added that there is no right to an automatic appeal right away. He added that any party could contact Judge Torres to request permission to appeal, and then they could submit their appeal request for consideration to the Second Circuit. Deaton clarified, "I didn't mean to imply that there cannot be an appeal prior to a jury verdict, only that there isn't an immediate right to an appeal. Either side can ask Judge Torres to allow it, and then ask the Second Circuit to accept. I don't see Judge Torres approving it because the SEC sought summary judgment in accordance with Howey, and the judge strictly applied the Howey factors to each type of XRP sale. The judge basically applied a non-controversial 76-year-old, well-established Supreme Court test to the facts of the case. If there were any challenges to her reasoning or any policy considerations on the face of a decision, why would she approve an interlocutory appeal? The court agreed that the Howey test was controlling and applied it accordingly. In addition, I would be surprised if Ripple would agree to an interlocutory appeal in order to cross-appeal on ODL sale. For instance, if I were representing Ripple or the two executives, I would jump out of my seat and pound the table as hard as I could to object to an early appeal, citing that this case has already taken 3 years, not including the 30-month investigation, and that this appeal would be premature. Ripple wants to use XRP for international payments. How likely it is that XRP overtakes other cryptocurrencies as the most popular one now that it has a bit more legal clarity in the US? Well, I don't know for sure if it will, but looking at the breakdown, the two biggest cryptocurrencies are currently Bitcoin and Ethereum. I believe Ethereum holds about 20% of the market, while Bitcoin accounts for between 45 and 50% of the market on good days. In full disclosure, we are one of Ripple's partners for their on-demand liquidity program here in Australia, so I do have a horse in the race for transparency. However, using something like an XRP token or other similar technology gives you a lot about speed and a lot about transparency, which is, in my opinion, the primary use case that Ripple have put forward with XRP. There's also another story there that's worth investigating, both for conventional finance and for potential cryptocurrency investors. There has been much discussion regarding Judge Torres' reasoning in the XRP judgment. Judge Torres will be reversed by the Second Circuit, according to a few well-known and reputable lawyers who claim that her outcome is incompatible with the basic premise or policy behind U.S. securities laws. I'll take that assertion on the chin. Crypto law. U.S. will address all of these concerns, and I'm bringing a lawyer who is the foremost authority on Howey and the appellate case law that followed it. In addition to the case law, there is no one better to address policy issues than a New York crypto lawyer. Lewis has worked with legislators regarding digital assets. The SEC is now pursuing Elon Musk. They truly have no shame at all. Fox Business's Charles Gasparino asks about Ripple, wondering if they'll be hit with a fat $1 billion fine because of that recent legal dispute. Alderati argued that the court's ruling will provide these financial professionals the assurance to talk about the problems they encounter with cross-border transfers, and those annoying developers worldwide can handle many D5 payments consumer application use cases thanks to high fees liquidity. And you don't need anyone's permission to communicate with the XRP ledger. Right now, there are no administrators because it's an open source, decentralized system. You just submit transactions, and everyone who participates executes them. I've had developers contact me with worries when everything was fine because their payments were so quick, cheap, and simple. They were worried that they couldn't possibly be doing it correctly. They say things like, "Wait, it says it's confirmed. I must not have checked right because it's only been a few seconds. No, it's that fast, that cheap, and that easy. I'm not making this up. In the past, we stop here for now. Thank you and see you in the next one."